So the first case, Ms. Rolfe, is Shallery Clark?
That's my
Oh,
understanding,
that's
Your Honor.
Mr. Pfeiffer's case?
Yes, Your Honor.
All right, let's call that case. So on the record in docket 23-00353, people of the state of Michigan versus Shallery Damone Clark. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Morning, Your Honor. Keith Driscoll on behalf of Mr. Shalor Clark.
Sir, you are Shalor Clark?
Yes, sir.
All right. This is the time set for a preliminary examination today. Mr. Pfeiffer, how we proceed?
Yeah, the people were prepared to proceed preliminary examination this morning. An offer was made to the defendant to plead guilty to count 2 and sentencing under 769-4A if eligible. In exchange, people dismissed count 1. The defendant appears to be accepting that offer, in which case we were able to take a misdemeanor plea this morning.
All right, so it's a plea to count 2, which is the
Domestic violence.
just a straight domestic violence?
Yes, Your Honor.
All right, plea to count 2, domestic violence. And then is there no objection to 769?
An agreement to 769-4A if eligible.
Okay, if eligible. And it's Mr. Driscoll?
Yes, Your
Okay,
Honor.
Mr. Driscoll, that's your understanding of the plea agreement?
That is, Your Honor.
All right. May I inquire of your client of his advice and rights?
Yes, Your Honor.
All right. So, Mr. Clark, you understand what the attorneys have said today, and you understand that the negotiation is to plead to count 2, which is domestic violence. That's punishable by 93 days and or $500. And you'll receive 769-4A status if eligible. Do you understand that, sir? And they've explained to you what 769-4A status means. Okay, with a plea to that count 2, count 1 is going to be dismissed, which is the underlying felony. Do you understand that, sir?
Yes, sir.
All right. I'm gonna walk you through some of your rights you have in this case. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses against you. You have the right to have the court order any witnesses that you may have in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. You understand your rights, sir. You also have the right to counsel. You're represented by Mr. Driscoll today. He could contest or cross-examine any charges brought against you at trial. Do you understand that, sir?
Sir.
All right. So if your plea is accepted, you'll give up the claim that the plea was a result of any promises other than the negotiations that have been talked about, or threats that it was not your choice to plead guilty. You'd also be giving them the right to appeal any trial rights because you're not having a trial, you're pleading guilty today. It's my understanding you wish to waive those rights and plead guilty today. Is that correct? All right. I'm going to bring your attention, so raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. I'm going to bring you back to November 10th of 2022 at the offense location of Delta Street in the city of Lansing. On November 10th of 2022, were you at the Delta Street address in the city of Lansing? All right. And this is a domestic assault involving Deja Jack, who is a person who you had a child in common or a resident or former resident or of individual whom you had a dating relationship. What was your relationship at the time with the Deja Jack?
Oh, she was just a mother and a child.
Okay, so you have a child in common. All right. So in count 2, why don't you indicate to me what makes you guilty of an assault and or assault of battery upon Miss Jack? Okay, you pushed her, which is an offensive touching of another, and you didn't do so in self-defense. Is that correct, sir? Okay. I find the factual basis to be understanding, voluntarily, accurately made. Mr. Pfeiffer, any questions about the factual basis?
No, Your Honor. I believe that's sufficient factual basis for the charge.
Thank you. Mr. Driscoll, anything?
Your Honor, I just like to make it clear for the record, this plea is conditioned on the acceptance of by the 769-4A.
All right. So if it's a Killebrew agreement, 764 and 769-4A. All right. And if if I do not follow the 769 kilobrew agreement, if you're eligible, I find some other reason, then you could withdraw your plea. You understand that, sir? All right, Mr. Driscoll, does that suffice?
That does,
Okay.
Your Honor. Thank you
Yeah,
so much.
I'm glad.
I just wanted.
Yeah, I'm glad you cleared that up for me. All right. So we will refer to probation. We'll refer to probation. So do you plan to do that today? Go down to the 5th floor to the probation office today to answer any questions? What'll happen is they'll fill out a report, and then on the sentencing date, we'll see what options are available to us. All right, so you'll refer to probation to the 5th floor. You'll report today just to get that done while you're here. All right, and sentencing date of? I don't know, about 10 weeks, 8 to 10 right now.
Oh, is that how far back up there?
Yeah, that's.
Okay.
10, I think, is probably, I think that's a fair assessment of where we're at.
Just trying to remember your.
Right.
Tuesday, May 9th at 1:30.
So it'll be Tuesday, May 9th at 1:30. Date of sentencing. So you're represented by Mr. Driscoll. Keep in contact with Mr. Driscoll for any questions you might have. And the sentencing date is Tuesday, May 9th at 1:30. All right, sir?
If I may, he does have a tether on currently. Will that be able to be removed today?
Response on removal of tether, Mr. Pfeiffer.
Just pled guilty to assaulting. All right, ask it remain in place.
I guess we can revisit it sentencing, but for right now, let's keep it on. All right. All right. Anything else for the record in docket 23-00353, Mr. Pfeiffer?
Not from the people. Your Honor.
Anything, Mr. Driscoll?
No, Your Honor.
All right. I will see you on May 9th. All right, sir? Thanks.
Yeah, okay.
Mr. Stevens, how are you?
I'm great, Judge. How are you?
I'm great, I guess. If that's the standard today.
Oh, well, I'm glad I got to set the bar.
Yeah, you did. It's all in your court. Ms. McComber, how are you?
Good, how are you, Judge?
I'm good. You have the other arraignment file.
Yeah, I put it in there with.
All right.
We can do that.
Yeah.
Is he here or?
Downstairs.
Okay.
I'm gonna grab Mr. Reedy.
Boy,
Yeah.
and bring him up in like a Hannibal Lecter.
Oh.
I'm in fear.
See you guys later.
All right, we'll see Mr. Pfeiffer.
The earliest I've ever gotten out of it.
Well, then run.
Oh, I
Run
am.
while you have the
Oh,
chance.
yeah, right.
Last time I did this is when Jake had to
You're
go and I had to cover.
Yeah.
So
Ms. Rolfe, how are you?
Not too bad, Judge. How are you doing?
I'm good.
The answer is great. Today's word
So
of the day is
word of the
great.
day is great, according to Mr. Stevens.
TGIF.
Mr. Milks, how are you today?
Fair to decent, I guess.
Great is what you're saying.
No,
That's-
Yeah, you don't have to
that's-
ask him.
Word
That's
was
a,
great.
Always one.
yeah.
It's a real simple one.
That means great here.
Yeah.
Yes.
It's
Oh,
a
boy.
category great.
Interpretation great. Subtitle great. I got your card.
Oh,
Thank you. I appreciate that.
you're welcome.
tape.
That's my job. That's what I've been doing for 9 months.
Oh,
First line is Mr.
No,
Smith.
this is- Oh.
We're doing the cross.
Yeah, we're doing the cross on.
She's doing the.
How are you, Susan?
She's doing a plead. Toby.
Pardon? Yeah, now it's.
Yeah.
Only-
We're not gonna go too
like
far,
40
because
minutes
those-
into it. So beware. 'Cause-
All right, I have Monday and Tuesday off.
Oh, perfect.
I'm feeling pretty good.
Yeah. Yeah, and we might, I mean, see how the weather goes, but
I like snow.
Do
I
you?
might be the only person.
I do too. The ice part of it in the band, you know, but, and I don't like, I honestly don't like to shovel, but, you know, but I'll do it. We haven't shoveled that much this
No,
year.
we haven't. I live in the country and my neighbor will come over with this plow truck and just do it all.
Yeah,
And then my kids like to do it. They love it. Yeah.
I think that's the key to raising children in the snow. Is the recreation in it.
Yeah.
Because that makes snow fun.
Yeah, and like they all love being outside, so they all love it.
My girls live in California now. They miss the snow. Not a lot of people can say that. Usually you're running from the snow.
Sometimes that's
Yeah,
that way.
people are. Mr. Carter,
Yes,
is that you, Mr. Carter?
yes, sir.
Okay, you may want to mute yourself because you're coming through the courtroom, so we can all hear what you're doing there, all right? And then when we call your case, you can unmute yourself.
All right, thanks.
You're welcome.
May I approach on a different file?
Sure, on the
Hernandez.
Hernandez file.
Mr. Austin,
Okay,
and I also had a motion and a order for some for the forfeiture file.
okay, perfect.
And then I don't know if I ever found it in the service.
Not sure. Let me see. I didn't have that file last I looked. Oh,
I can take it downstairs just in case.
3001 here.
176.
I don't see a proof of service.
Okay, it says no service on it.
Okay.
You want me to see? All right. All right, so I'll put it in there and then you let me know when you're ready.
We're ready.
Ready to
Whenever.
go?
I will. Mr. Hernandez, there's some kind of cumbersome, so. Does it matter how the hallway feel like over-
All right, let's bring her in. Let's put it on the record.
Okay. We'll get her ready.
I think we're just waiting for somebody to be brought up right now. He could be holding up.
Those things don't- Certain repeat a lot. That'll be-
But I have a tendency to do that, so.
That's what I told him too. I forgot. Yeah,
That was.
Yeah.
Okay. Well, we got a few things lined up to buy you some time, or him some time, not you, you can care less. Yeah, that's easy.
Yeah, I need more counter space. It's
Made
not,
myself
you
as
didn't
small as
design it, did
possible.
you?
May I approach?
You may.
I don't know if you were notified this.
As an arraignment file.
Okay, yes, all right.
So
good.
we'll arraign him on it
And then
too.
the idea of that we've, this, Mr. Carter and I have discussed in today's case will align with the exam dates.
All right.
I anticipate we'll rope all of it together.
All right, you just let me know. So I have the forfeiture file. I don't know if I have the. So it's a plea today, right?
It is.
I don't know if I have the warrant file.
Exam today as well.
Yeah. So I have the forfeiture file that was set. But I don't have the preliminary examination file. Let me see if I can find that. I don't. This is Lavoy. Strunk. So let's do this. Let's go forward on the files. And then I'll just have, and you can indicate the record. And then I'll have Nathaniel pull the
Okay.
other file. Because all I have is the forfeiture file. For
It's
some
not one of the
reason.
ones on the bench, Judge.
Yeah, I don't have all the preliminary examination file, but at least the one file. Once. Well, this says 176. Let me see if I can find 17. No, I have it. We're good. And I do have an order of fingerprints, Mr. Austin, so your client should probably get their fingerprints before we do any. You're all set? Okay. Okay, good. And that hasn't been that's been the usual case, so I'll just stick that in. All right, so we're on the record in docket 23-00178 and docket 23-00176 GZ. That's State of Michigan versus Ashley Hernandez in both the preliminary examination files and the forfeiture files. Would the parties please introduce themselves for the record?
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
And good morning, Your Honor. Jared Austin appearing on behalf of Ms. Hernandez, file 23-178FY, and she is present to my right.
Okay. And ma'am, you are Ashley Hernandez?
Yes, sir.
All right. This is the time set for, we'll start with the preliminary examination file, but my understanding is they've all been placed together, but we'll start with the preliminary examination and then we'll go to the associated hearing file. Ms. McComber, how are we proceeding today?
Thank you, Your Honor. Today we will be proceeding with a misdemeanor plea.
And so the plea will be to,
The plea will be to an added count 9 of animals abandoning or cruelty.
okay, and what's the PAT code on that?
I mean, 2 to 3 animals, Your Honor, it would be 750.504B. It's a 1-year misdemeanor, up to $2,000 in fines, up to $300 of community service.
And it can be up to 300 hours
Yes, Your Honor.
of community service, okay.
Court may order a psych eval, the cost of care, housing, or vet care. Defendant may be ordered to not own or possess.
Psych eval may be ordered. No animals may be ordered.
And the cost of care, housing, and veterinary care.
Cost of care may be ordered. And if you would please, that PAT code again?
750.504B.
Do they plead to count now at 9-1, the added count 9 counts 1 through 8 will be dismissed?
That's correct, Your Honor.
And is that your understanding, Mr. Austin?
One moment, Your Honor.
Now, there is also a killable agreement in this case to no further upfront jail the time of sentencing, so long as the defendant agrees to any and all terms of probation deemed appropriate at sentencing.
Okay, Killebrew, no upfront jail. As long as defendant agrees to terms of.
Under court supervision.
According to statute.
Okay,
It doesn't matter.
we've had issues with that, so
Okay.
just let me know.
Okay, thank you.
We'll blame you, but you just let me know. We'll actually blame Wendy. She's not here, so that'll be the easy one to blame. We'll just say it's Wendy's fault. What was the last condition again?
That the defendant agrees to not own or possess animals while under court supervision. Just for the record, Your Honor, the people will be requesting that the court order a psychological evaluation. It's not part of the plea agreement. It's just a request by the people. Restitution will be determined by sentencing.
All right, so Mr. Austin, I'll restate that for the record, and then you can indicate for me if there's anything I've missed. There's gonna be an added count 9 of abandonment or cruelty to 2 to 3 animals pursuant to 750.504 parents B. Counts 1 through 8 are going to be dismissed. What the defendant's pleading to is a 1-year misdemeanor and or $2,000. Up to 300 hours of community service may be ordered. The court may order a psych evaluation. It appears that people will be requesting a psych evaluation. There's also an agreement, or there's also the court may order the defendant not to own any or possess any animals, and the cost may include any care for the animals. Is my understanding, care or treatment. There's a Killebrew of no upfront jail as long as the defendant agrees to the terms of probation. Is that your understanding, Mr. Austin?
Yes, Your Honor.
All right. And inquire of your client of their advice of rights.
Yes, Your Honor.
All right, and it's my understanding, Mr. Hernandez, that you have signed an advice of rights form that is in the court file. You understood and read the advice of rights and plea information that was presented. All right, so I'll only go over 3 real basic rights for you. I won't go through them all. You know, you have the right to counsel. You, of course, are represented by Mr. Austin. He would contest or cross-examine any charges brought against you in this case. You understand that? You understand you have the right to jury trial in this matter. So you have the right to that type of hearing, and you understand you have the right to silence. Not testifying in court cannot be used against you. Do you understand that?
Yes.
All right. With that understanding, I have the advice of rights in the file concerning all the rights. I've addressed the larger rights. May I inquire of your client on a factual basis, Mr. Austin?
Yes, Your Honor.
Okay, I'm going to have you raise your right hand, ma'am. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention back to September 30th of 2022. And I would indicate for the record, the address would be, is that the Cleveland Avenue address?
Yes, sure.
Okay. So you were living at Cleveland Avenue in the city of Lansing on September 30th, 2022. Is that correct?
Yes, sir.
All right. And my understanding is the allegation is that you did fail to provide for 2 or 3 animals adequate care or abandonment for 2 to 3 animals, fewer than 2 to 3 animals, without making provision for the animals' adequate care, or negligently allow for those animals to suffer, or did negligently allow for those animals to suffer unnecessary neglect, torture, or pain. Why don't you tell me about count 9 and what happened in regards to those animals?
Animal control.
Okay, and at the time, were you responsible for the 2 to 3 animals?
Yeah.
All right. And at the time, did you negligently allow adequate care for the animals, or did you abandon the animals?
Inadequate care.
Inadequate care, okay. So this is the nature of its inadequate care, negligence as to the inadequate care of 2 to 3 animals. Is that correct, Ms. McComber?
Yes, Your Honor.
All right. And all right, anything towards the factual basis, Ms. McComber?
I don't know if the court wants to go into detail about the inadequate care or not, or if the court is satisfied with.
What was the nature of the inadequate care, ma'am?
My ability to get them in and out safely, due to my.
All right, so the inability to take care of them due to your circumstances.
Correct.
Which would be feeding or anything else along those lines. All right, Ms. McComber, anything else towards the factual basis?
No, Your Honor.
Mr. Ross?
Satisfied, Your Honor. Thank you.
All right. I find the factual basis to be knowing, voluntarily, and accurately made in regards to this file. We'll refer this to probation. And ma'am, do you plan on doing that today to the 5th floor to just go and answer any other questions? All right, and what they'll do is, we're about 10 weeks out right now, but what they're gonna do is they're gonna provide a report to me, and then we'll see what options are available in 10 weeks, all right? There is a killabrew of no jail time if you follow probation's recommendations. If I decide not to follow that killabrew, you will have the opportunity to withdraw your plea. Do you understand that?
Yes, sir.
All right. Date of sentencing,
May 9th at 1:30.
okay, so set it for May 9th at 1:30 for sentencing. Any questions in regards to the preliminary examination file of 23-00178, Ms. McComber?
No, Your Honor. Thank you.
Anything, Mr. Austin, on the preliminary examination file?
One moment if I may, Your Honor.
All right.
Your Honor.
Yes. Is there anything you want to put on the record in regards to that file?
The court may have covered it, but I don't recall the court asking specifically Ms. Hernandez how she wished to plead to the added charge, whether she was pleading guilty or not.
I can ask her. She laid a factual basis for it.
Correct. I
But-
just wanted to make sure.
So your wish today was to, and on your advice of rights, your wish today was to plead guilty to count 9, which you've already done.
Yes, sir.
All right. And you're waiving your trial rights and all this matter, including the advice of rights that you already admitted to the court.
Yes.
All right. Anything else, Mr.
With that, I had nothing further.
All right, thank you, sir. So that's all for the record and docket on the preliminary examination file of 23-00178. And then we have the formal hearing file, the forfeiture hearing of 23-00176. Ms. McComber, how are we proceeding on this file?
Your Honor, the people have provided the court with a motion to dismiss that file as well as a prepared order on that. Ms. Hernandez did file surrender forms for all the animals that were seized and are still alive in this case. This morning, I do have those surrender forms and we'll be turning those over to Ingham County Animal Control that releases all ownership of each animal from Ms. Hernandez to the Ingham County Animal.
And that's your understanding, Mr. Austin. They're moving to dismiss. I have the order. You've had the opportunity to review the order.
Yes, Your Honor, that's correct. That's my understanding.
All right. This advice of rights goes through that. All right, so I will sign the order for dismissal in the case. And I'll also place the proof of service along with the dismissal. So the forfeiture hearing has been rectified and the case is dismissed. Anything else in regards to docket 23-00176 GZ? Mr. Austin,
No, Your Honor, thank you.
anything, Ms. McComber?
No, Your Honor, thank you.
All right, we should be all set on those 2 files. we'll see you in 10 weeks. All right, ma'am? Okay,
All right, thank you, Judge.
thank you. Mr. Milks is your client. Oh, there it is. All right, and that is
Reading with the
Reading.
3 docket.
All right, we're on the record in docket, in 3 dockets, and we'll handle them both separately or all together, but I'll call all 3 cases 23-00492, 23-00493, and 23-00497. People of the state of Michigan versus Joshua Reedy. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Andrew Stevens on behalf of the people.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Reedy, who is present and seated to my right at this time.
And sir, you are Joshua Reedy?
Yes, sir.
Okay, this is the time set for a preliminary examination. Mr. Stevens, how are we proceeding?
Thank you, Your Honor. I'm actually going to defer to Mr. Milks. I would just indicate to the court that Mr. Milks and I spoke yesterday at length regarding all 3 of these cases. So much of what I anticipate Mr. Milks is going to convey to the court, I would agree with. And so at that point, at this point, I'll just defer to him.
All right, Mr. Milks?
Thank you, Your Honor. Our plan here is uniform across the 3 cases, Your Honor, but we are requesting an adjournment at this time. I've gone through with my client his right under the 21-day rule, or it was formerly the 21-day rule. And he does wish to waive the 21 days in order to have an adjournment here due to the volume of discovery and that it's still coming in at this point. And I believe we received just about everything at this point from the prosecutor's office, just the nature, the volume of everything, Your Honor. We are requesting more time. Regarding a preliminary exam date, Your Honor, I spoke with Mr. Stevens. We might want to maybe block off a morning for 3 cases here. I don't know the number of witnesses Mr. Stevens anticipates to call, but with these 3 cases here, it might be wise to at least, or prudent at least, just to.
All right.
That way.
Mr. Stevens, is that under your understanding? So the first one is adjournment waiver of 21-day rule for ongoing discovery on multiple files, and then to set aside some time for the prelim date.
I agree with all of that.
All right. So first things first, let's go with Mr. Reedy on all 3 files. Mr. Milks, may I inquire of your client of his waiver of the 21-day rule on all 3 of his files?
Yes, thank you.
All right. So, Mr. Reedy, in regards to 23-00492, 23-00493, and 23-00497, all 3 files, you have the right to a preliminary examination within 21 days of your date of arraignment. Do you understand that, sir?
Yes.
And the preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed the crime in all 3 of these files. Do you understand that?
Yes.
It's my understanding, you of course have a right to counsel in that hearing, and Mr. Milks would be available to cross-examine any witnesses and contest any charges brought by the people against you. Do you understand that? It's my understanding today that you have a right to a prelim within that 21-day period. And it's my understanding that there's ongoing discovery issues concerning these 3 files. So it is your right to have that within 21 days. If you waive your right to a preliminary examination within the 21-day period, you won't be waiving your right to a prelim. You'll only be waiving your right to have it within the 21-day period. Is it your right today, because of ongoing negotiations and discovery issues, is it your wish to waive your right to a prelim within 21 days? Okay, so I'm going to indicate for the record, your agreement today is to waive your right to a prelim within 21 days on 23-00492, 23-00493, and 23-00497. Is that correct, sir? Okay. I find that the waiver of the 21-day rule to be knowing, voluntarily, and accurately made, and then we will set it for prelim on a date that we can block off some time. So I would probably look for like in the past we've done like an afternoon. Nathan, what do you think, Nathan?
Just kinda legit.
I'll check with them. It might, because there might be a trial schedule, but
Monday, April 3rd, doesn't hit as an ordinance day, but there's not a lot scheduled right now.
that's usually,
So nothing after 9 o'clock until 2 o'clock.
so how does Monday, April 3rd look? At 9:30. You gotta find your schedule,
Yes,
Mr. Miller.
sorry.
That's okay.
April 3rd, that is Monday.
Yeah, Monday, April 3rd.
Yeah, you're on those, that looks good for me. Thank you.
All right, so Monday, April 3rd at 9:30.
Yes, that's fine. Thank
All
you.
right, so we'll set it for Monday, April 3rd at 9:30. Mr. Reedy, if you have any questions concerning that date, please keep in contact with your attorney, Mr. Milks, and he'll provide you with any answers or any issues that you have, okay?
Sir.
Anything else on the record in dockets 23-00492, 23-00493, or 23-00497?
Nothing on behalf of the people.
All right, Mr. Milks?
Nothing from the defense. Thank
All
you.
right, we'll see you back here on April 3rd. All right, sir? Mr. Milks, is that your only case with this?
I had one other one.
All
Your Honor.
three of those?
We took care, yeah. Took care of everything else, though, I think.
All right.
No.
There's Mr. Reedy's phone.
Doesn't change it. Right, I send it out complete.
How are you, Mr. Callwriter?
I'm good, Your Honor. How are you?
I'm good. Did you want to go on? We have Mr. Carter and Mr. Steen, I think.
Correct. If we could do that one, we can get Mr. Carter.
All right.
completed.
All right, so we'll do Mr. Skeen. And we'll do the prelim first, and then I can arraign him on the second one.
Perfect.
All right. All right, Mr. Carter, we're ready on Mr. Skeen's case. We have a preliminary examination file, and then there's an outstanding file that he needs to be arraigned on. We'll go ahead and do that right now too, all right?
Yes, Your Honor.
All right, perfect.
Your Honor, for the record, I did discuss with Mr. Skeen what the prosecutor and I had discussed about how to proceed forward with my case that I represent him on now in this new case that he is being arraigned on, and he is in agreement with that.
All right. All right, so we'll call to the record docket 22-03307, people of the state of Michigan versus Glenn Skeen. Will the parties please introduce themselves for the record?
Andrew Stevens on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Skeen, who is participating through the MDOC Polycom system.
All right, sir, you are Glenn Allen Skeen.
Yes, sir.
All right, and you can hear me all right, Mr. Skeen?
Yes, sir.
All right, this is the time set for preliminary examination on the file. Mr. Stevens, how are we proceeding?
Your Honor, today on this case is as the court indicated, the date and time set for the preliminary examination. And speaking with Mr. Carter and certainly advising him of the new case that Mr. Skeen will be arraigned on here momentarily. that I was able to get sort of arranged for today, so we can get as much done at one time. I believe it will be certainly Mr. Carter's request, and I join in the request to have today's preliminary examination adjourned to the dates that correspond with the dates for the new case, so we can handle both of them together.
Okay.
And Your Honor, that's a correct statement, but for clarification, I'd ask for this case to actually be set for the PCC also. So basically having another PCC on this case instead of setting it just for the preliminary exam on the date of the other preliminary exam.
Right.
And
So let's
I
see
think
if
that's
we
what
can-
Mr. Stevens was trying to indicate.
Right. Let's see if we can find so we would so we're gonna arraign him on an RNC felony. And that'll need a PC and PE, and then we'll just set this at the same time.
Yep.
Do you have a date for that?
Yep, probable cause is gonna be March 10th at 9 o'clock.
March 10th at 9 o'clock for the probable cause conference,
March 17th at 9 o'clock.
and March 17th at 9 o'clock for the prelim. Now, we do have a notion of good cause here. I would say there's probably good cause here to adjourn. However, Mr. Keene can waive that 21-day right if he chooses. Do you know how we're going to proceed in that regard, Mr. Stevens?
As far as on this case that I represent him on now, I have discussed that with him, and he would waive any challenge to the 21-day rule, but I believe that has been waived previously because of good cause.
Let me see. Oh, I didn't look to see. Oh, he previously waived his 21-day rule on December 15th, 2022. So that's not an issue. All right, so you have the March 10th date at 9 a.m. for PCC and the March 17th for prelim. And then we'll make sure that the new arraign file is set for the same time. Anything else for the record in docket 22-03307, Mr. Stevens?
Nothing from people. Thank you.
Anything, Mr. Carter?
No, Your Honor.
All right, and then I'll go ahead and arraign him on the pending file. So, sir, you understand there's a pending case against you, and this is the time set for arraignment on the felony case. And I'll go ahead and arraign you on the felony case, indicating to you what the nature of the charges that have been alleged against you. All right, sir?
Yes, sir.
All right. So we're on the record at 23-00641, and parties would introduce themselves for the record.
Andrew Stevens on behalf of the people.
All right, Mr. Carter, you've already talked to him, but you're not, are you officially representing Mr.
Well,
Skeen on this case?
thank you, Your Honor. Your Honor, I will appear as a limited appearance at this point in time
All
for
right.
the arraignment, as I was conflict counsel out on that other case, and I don't know if the public defender's office will assign this case to me, but I'm confident that I could represent him in a limited appearance for the arraignment.
All right, so Mr. Carter, you're appearing for arraignment purposes only. Sir, you are Glenn Skeen once again?
Yes, sir.
All right, I'm going to read you the nature of the allegations that have been brought against you in regards to this felony complaint. It's alleged that on November 15, 2022, at the offense location, the city of Lansing, that you did, Glenn Allen Skeen did in count 1, buy, receive, possess, conceal, or aid in the concealment of 2004 Chevy Avalanche, a stolen motor vehicle, knowing or having reason to know or to believe that the motor vehicle was stolen, embezzled, or converted contrary to laws of the state of Michigan, that being 750.535 parent 7. It's a felony, 5 years under $10,000, or 3 times the value of the motor vehicle, whichever is greater. The court may impose a fine of 3 times the value of the motor vehicle, which could be determined by the trier of fact. Also, the court may order state or local government of expenses to be incurred and in regards to restitution pursuant to the laws of the state of Michigan. And there may be DNA collection in regards to the sentencing or disposition of this case. Mr. Skeen, do you understand the nature of the allegation that's been brought against you?
Yes, sir.
Okay, in this felony case, you have the following felony rights in this, and I'll walk you through those briefly. In this case, you have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty. You have the right to have witnesses appear at trial. You have the right to question those witnesses. You have the right to have the court order any witnesses to appear in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. So you are represented by Attorney David Carter for limited purposes of this arraignment. Do you plan to seek additional representation from the Public Defender's Office in this file?
Yes.
All right. I'll indicate that for the Register of Actions. The dates in this case were set at, I still have my handy arraignments already. So the dates are set, probable cause is set for, I'm gonna need that.
Oh. March 10th.
March 10th at 9 a.m. The prelim is set for March 17th at 9 a.m. Preliminary examination, as you know, is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. You, of course, could be represented by counsel in that proceeding. Do you understand your preliminary examination right in this case, sir?
Yes, sir.
All right. Do we need to writ them out for that March 10th or March 17th date?
Yes.
Yes.
Okay. So we'll writ out for that, for both dates or just the 17th?
Both dates. Yeah, actually, he can do polycam on the PCC. But
That was what I was going to say.
Say it again, sir.
Video for the 10th,
And then,
I'll have a in-person writ
right,
for the 17th.
for the March
if we
17th.
need it.
All right, for March 17th at 9, we'll writ out of DOC. The current address and phone number will just indicate a defendant is in the Department of Corrections. Sir, are you currently on probation or parole?
No.
Yeah, I'll enter a not guilty for purposes of this arraignment on the new felony file. Mr. Carter, if you want to, you can be heard on bond in this case.
thank you, Your Honor. Your Honor, I'd ask for $100 cash bond in this matter. He's in MDOC. He's not going anywhere. He was sentenced to 17 months in the Department of Corrections out of Shiawassee County. However, just to make sure that if in fact jail credit becomes an issue, I do not want him getting a PR bond at this time, and I don't believe he's going to be able to post any bond anyway. So, but I would ask for $100 cash bond.
Mr. Stevens.
I'll defer to the court. The issue will be he's serving a sentence on an unrelated matter. He's not going to get credit for it. So
I'll set it at $1,000, 10%, and then I'll let it work itself out. Okay. All right. The defendant is currently in MDOC, so I'm not gonna. I'll just do the bare minimum of bond conditions, since he has no use of drugs or alcohol, no out-of-state travel, no firearms, and a report to pretrial services within 48 hours. As a part of the bond conditions. All right. Anything else for the record in docket 23-00641, Mr. Stevens?
nothing from the people. Thank you.
All right. Anything, Mr. Carter?
Nothing.
All right. Mr. Skeen, you'll be writ out for March 17th, and we'll see you then. You have a probable cause conference on March 10th. We'll see you by video on that date. All right, sir?
Sir.
All right, that's all for the record, docket 23-00641. You're all set in at TOC. Thank you for your appearance today.
Thank you, Your Honor. Thank you, Mr.
Thank you,
Stevens.
Mr. Carter.
Thank you. I'm gonna concede the floor to.
You're gonna leave us on this wonderful day?
No, I'm not done yet. With some of the timing and everybody's ready for this one. And my understanding is the continuation of the exam isn't going to take very long. It'll let me clean up the rest of the matters.
All right, all right.
Yes, Your Honor, if we could do the continuation on Captra Davis.
All right, let's see. Davis. Folder there on this Davis. Usually up there. I'll have my notes from the first. It was pretty brief, so it's not like pivotal there. Oh, that's not one. That's what it would look like, but I think we're okay. I also have the transcript from the first. All right. Nope, no problems. So we're back on the record in docket 22-00300. That is People of the State of Michigan versus Captra S. Davis. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Kristen Rolfe on behalf of the people.
Good morning, Your Honor. Toby White on behalf of Captra Davis. She is sitting to my right at council table.
And ma'am, you are Captra Davis?
Yes.
All right. This is the time set for a preliminary examination, and this is actually a continuance from a preliminary examination. Testified at the first. So Jonisha Powell testified at the first when we started the prelim. So are there any pre-trial preliminary examination matters to come to the court's attention before the people calls their first witness?
Your Honor, just to refresh the court's recollection and the record, we did start with the victim, Ms. Powell's direct examination. We're continuing today for cross-examination. I will say the court referenced having a transcript from the first hearing. I am not in possession of that. I don't have it in my file either. I'm not asking for an adjournment by any means. I was present for that examination,
Right.
and so I do recall what transpired and what was testified to. But just for the record, I do not have that transcript.
All right. And if you'd like to review that transcript before you make your motion for bind over, we could take some time. So.
Okay,
Okay.
that might not be
All
necessary,
right.
Your Honor. And just to refresh the record again, the people at the first exam put our intention on the record that if the proofs support, we'll be seeking to add 2 charges to this exam. The first one being CCW, carrying a concealed weapon, and the second one being felony firearm in connection with the already charged felonious assault.
All right.
Just to update and refresh the record for all of that.
All right. And okay. So let's get a changeover. Susie. Hi, Annie. How are you, Eddie? I'm good. Just let me know when you're ready.
Okay.
Well said. All right. So Mr. White, you've heard Ms. Rolfe talk about the nature of the hearing. I am in possession of the session one preliminary examination. You, of course, are entitled to review it if you wish. But my understanding is that we adjourn for your cross-examination. Is that correct?
That's correct.
All right. So at this time, as long as there are no future witnesses, and I'll leave it to council to let me know if anybody's in the courtroom that shouldn't be in violation of the sequestration order, we'll call the witness for cross-examination. So what, Mr. White?
One more thing. I had discussions with Ms. Rolfe. There was an offer extended in this manner, and it's my understanding that offer will continue on to circuit court, notwithstanding if she adds some additional charges.
Is that fair, Ms. Rolfe?
That is correct, Your Honor. The offer will remain open.
Okay. So offer to remain open, and I'll make that note in the file and in the notes. All right, so Jonisha Powell can retake the stand. Ms. Powell, go ahead and come up here, and I'm gonna have you remove your mask and restate your first name and your last name and spell them for the record.
Jonisha Powell, JOHNPESHA
Okay, I'm gonna have you raise your right hand, use your other right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, go ahead and have a resit there and project to the back of the courtroom for, you can remove your mask if you choose, so we can hear you. And Mr. White, you may proceed.
Thank you. Good morning, Ms. Powell.
Good morning.
I just want to review a couple of points that you brought out the last time you testified. And I would say, Your Honor, for the record, by the way, I do have the transcript.
Okay,
I'm
good.
working from it, and if at any point Ms. Rolfe would like to see it, obviously I'll share it.
All right, thank you.
All right, at one point you said that you came out of your unit, you call it a unit, is it an apartment? Is that what it is?
It's a townhome. No, a townhome, but it's basically an apartment complex with multiple units in it.
All right, and so you came out to take your dog out to let him do his business?
Her, yeah.
Her, okay. Yeah, it's a pit bull, is that what I
Yeah.
understand? And she was leashed at the time?
Yes.
Right. Is she a big dog?
Medium size.
It's like 60, 70 pounds?
Yeah.
Does that sound about right?
Yeah.
All right. And when you came out, there were two women that were out in that vicinity, right?
Mhm.
Were both of them?
Yes, ma'am.
Yes.
Okay, thank you.
Were they both outside on the sidewalk area?
Yes.
All right. And did you recognize either of them?
Like,
Did you know who they were?
no. I mean, I knew one of them lived in the complex.
Okay. And at the time this incident took place, did she live in the complex?
Yes.
And was that the older woman or the younger woman?
That lived there,
Yes.
the older one.
All right. And the younger woman is Miss Catra Davis that's seated beside me here, who you identified the last time we were here, correct?
Yeah.
And so was it daytime or was it nighttime?
Daytime.
All right. So visibility was fine. You could see, correct?
Yeah.
I see you wear glasses. Were you wearing glasses at that time?
Yes.
And then you asked the older woman, Ms. Davis Senior, I will call her. You asked her if she had stolen some packages from you?
Yes.
Tell-
Not really stolen. Did you did you see him? Did you take him? Basically.
Okay, all right. And when you asked her that, did you ask her that just like you asked it to me now? Or was your voice elevated?
I was like, did you see my packages?
I understand. I heard what you said. My question was as to your demeanor and your tone.
I said it just how I said it. There wasn't no bass, no anger, no nothing.
Okay, and then you say that Ms. Davis Senior, did she start yelling at you or just Ms. Catra Davis that's here in court today?
She started, the mom started yelling at me.
Okay, all right. And when the mom yelled at you, where was Catra Davis?
Standing next to her,
Standing next to her? Okay, and where was the car?
behind them, they was standing on the side of it.
Okay,
Like, basically the car was on the road and they was standing by the sidewalk.
Oh, okay, all right. And were the doors to the car open or closed?
Close.
All right. And so you approached her and asked her this question in a conversational tone, correct? And
yes,
that's a
ma'am.
yes?
Yes,
Okay.
sorry.
Conversational tone, and then, so and you're saying she elevated the interaction by yelling back at you.
So I yelled back. Yes, so I yelled back.
Okay, so the two of you kind of started yelling at each other.
Mhm.
What'd your dog do?
Your Honor, just for the record, can you say, is that a yes or a no?
Yes,
Did I
Thank
let
you.
go by?
sorry. So when my dog when they started yelling or whatever, my dog got a little rowdy because you're yelling.
Okay, what's a little rowdy mean to you?
Like she was trying to pull like towards them
Okay,
and she was barking.
I'm gonna object to the relevance of this testimony.
Response?
well, Your Honor, if we're headed towards a felonious assault, then I'm just trying to lay a foundation. Again, we've got concern sometimes with people reappearing, and I want to lay a foundation for a self-defense if an aggressive dog is coming toward you.
All right, I definitely think it's relevant in regards to the interaction between the two parties. So I'll overrule the objection. You may proceed.
Thank you. All right, now, you said in previous testimony that the only people that were there that witnessed this event were Miss Davis Senior and Contra Davis that's here in court today.
Yes, but I was also on the phone with my friend and she heard the whole thing.
I understand.
But like you said the last time, you can't really hear a conversation
Okay,
over the phone.
all right. And then, okay, but and in this escalation, did you ever use the words like, you stole my packages or you took my stuff or anything like that?
Yes, I did.
Judge, I'm gonna object. A lot of that is hearsay. I mean, I've let some of it go, but it's an out-of-court statement made by this
Ma'am,
victim.
Ma'am, hold on. Just write down what you need to talk to counsel.
I'm sorry, Your
because
Honor. Yes.
Whatever you say is going to be picked up and they're going to write it down.
Yes, Your Honor.
And I don't know if that's what you want.
Yes, sir.
All right, go ahead, Ms. Rolfe.
And I believe it's being used for the truth of the matter asserted. It's impermissible hearsay. I do not see an exception, so I'm
All right.
objecting. at this time.
Objection is to hearsay.
Can I respond?
You may.
Yeah, there's no hearsay. This is not for the truth of the matter. She didn't steal the packages. These are just two people having an argument.
If it's not offered for the truth, I'm not using it in order to assess the nature of the bind over. I'll allow it. The objection's overruled.
Thank you. Now, what was Miss Davis Senior wearing?
I don't know. It was over a year ago. How
All
am I
right.
supposed to remember?
All right, and that's fine. And even that, when the police interviewed that day, correct?
Yes.
And that day, you were not able to identify what clothing people were wearing, were you?
No, they didn't even ask me that. They
Okay,
didn't ask me what were they wearing. They asked me what vehicle was in.
all right. And so that would mean you also don't know what Miss Contra Davis was wearing.
No, well, can I say something?
Well,
You
just
can
answer the question.
No,
Okay. And did you notice that there was a 9-year-old child with the two Davises?
yeah, I knew it was a child in the car or something, but
Okay. So on direct exam, and even now, when I first asked you, you said there were only two people there. But now under further explanation, you're changing your story and you're going to say there were three people there?
next question, please.
But no, you have to
I
answer
don't
the
have
question.
nothing to say to that.
But you got to answer the question, ma'am. So is there three people at the scene or two people at the scene?
Your Honor, if I may say something,
Sure.
just for the record, Ms. Powell, just so you understand kind of procedurally what's going to happen. Mr. White is doing cross-examination right now. I will have an opportunity to do redirect to possibly ask you more questions and clarify questions
I
like
don't
that.
remember.
Just so you know, so please do answer the defense's questions at this time.
Well, I don't remember. So.
Okay.
And that's a fine.
All right. That's fine. So you don't remember the third person at today's date?
No.
All right. And did you notice that there was a 10-month-old baby
No,
involved?
no,
And just as to the young child, first you said you did see him. Now you're saying you didn't see him.
I think she says she doesn't remember.
Okay, but there was testimony here, Your Honor, where she did say she did see him. So
Well, I don't
she's changing her
remember.
story, so.
I'm gonna ask that be stricken from the record. This is a cross-examination. The format is question and answer. There is certainly no space for commentary on the defense, so I would ask that be stricken from the record.
All right, with that understanding.
Clarifying the
objections
record, that's
sustained.
all.
Okay.
Clarifying, and I'll move on. Okay. So now let's talk again a little bit about the gun. What do you remember about the gun?
I don't know anything about guns. I don't look into guns. I don't know nothing. So I just know it was small.
You just know that it was a small gun? Okay, do you know what color it was?
Silver.
All right. Do you remember at one point in time saying it was black?
Yep, I remember the last time I was here.
All right. So was it silver? Was it black?
It was silver.
All right, why did you say it was black? Last time we were here.
Like I said, I don't remember. It was over a year ago. I got other things on besides that.
Okay, so you have other things on your mind other than answering Ms. Rawls' questions when you were here last week.
Yes, I have other things on my mind besides the.
Okay. And where did the gun come from?
Inside her coat.
Show me.
She had a hoodie on and a coat.
What color was the hoodie?
Your Honor,
I don't
I think-
remember.
for the record, Mr. White asked the witness to do a gesture. I would just.
Right, I didn't get to see
A
it. but-
description of the gesture. for the
Yeah,
record.
so do you have a description of the gesture? I didn't get to see it because I can't see from here.
Let me clarify on that. So you gestured across your chest. So she had a hoodie on, correct?
A hoodie on and then a coat.
And a coat. And so what color was the coat?
Black.
Okay. And then she opened it as I'm gesturing
She
here.
was reached in and then showed it.
Okay, so.
Again, for the record. can you
Okay,
just-
so
Yeah,
so that I did see. So the witnesses indicated that, first of all, the question was, did she reach in her jacket? The answer was she reached in and then she pointed out her arm extended straight in front of her with a finger pointing. So the record may reflect that the witness made that gesture. You may proceed, Mr. White.
Thank you. Yes, so we're clear. She reached with her right hand.
I don't know what channel. I'm just saying that she reached in her coat, whatever it was, and pointed it at me.
Okay, and the coat or the hoodie, what color was the hoodie?
I don't know what color the hoodie is, but the coat was black.
Coat was black. Okay. And that frightened you,
Yes.
is that correct? Now,
And she stated that she's gonna kill me and my dog.
and then I want to know what you did after she pointed the gun at you and made these alleged threats.
Basically, I bagged up.
I don't know what bagged up means. I'm sorry. You'll have to tell me.
I stepped back. And then I called the police as I was walking back into my unit.
Okay. And this interaction, you said before, took 10 minutes?
I guess, you know,
So let me try it this way. Last time you were here, you said it took no more than 10 minutes?
No, yes, no more than 10 minutes. It
Okay,
don't take that long
all right,
for the situation to happen.
all right. So it didn't really take up to 10 minutes, did it? It was much less than that.
Yes. You just guessing. No more than 10 minutes.
Were both Contra Davis and her mother, Ms. Davis Senior, I've been calling her, were they both yelling at you?
First it was the mom,
Okay,
and then she had a couple words or whatever she had to say. I don't.
okay. When you use she, you have to tell me which she you're talking about. First
The
the mom,
daughter.
and then what? Then the daughter had a couple of words?
Yes.
Okay. And you remember what the couple of words were?
No.
Okay. And you resented being yelled at,
Yes.
and you yelled back at her.
Yes.
What'd you yell back at her?
You said when?
What did you yell
Judge-
back?
Again, if he's eliciting hearsay, it's an out of court statement. And I don't know if it's being used for the truth of the matter asserted, but I'm going to object.
Yeah,
You're right.
objection hearsay.
Okay. A misunderstanding of the question. I asked her what she yelled at Miss Davis. That's
It's still hearsay. It's an out of court statement offered for the truth right at this point.
Well,
Even if she's here to be cross-examined, by definition, it's still hearsay.
that's fine. Then I'll take the truth out of it and just say, we're trying to characterize this interaction and for the effect on the listener, many other reasons why we would want to know what she yelled back at her, other
Judge.
than the truth.
Ms.
And
Ralph,
Judge, if he's trying to elicit something for the truth of the matter asserted, he can certainly ask it in another way. And based on what you said, instead of asking what exactly was said, based on what somebody said, then what did you do based on that?
Okay.
You don't have to ask for exactly what was said. You can say, based on what was said, what did you do next?
all right.
What happened? what
With that
kept it
understanding,
going?
if it's
I'll rephrase.
rephrase.
Okay. Your response was verbal, correct?
Yes.
And when you did this verbal response, it was loud, correct?
Yes.
And when you did this, was it a threat?
No.
All right. It was just you yelling loud.
Yes.
Okay. Did you say you're not going to yell at me?
Again, same objection, Your Honor.
Yeah,
No, Your Honor, I'm asking her if she said that. She can say no or yes, that's not.
yeah, but
hearsay.
the response would call for a hearsay answer, so I wouldn't sustain the objection unless you have an exception to the hearsay rule.
First of all, threats are not hearsay. Threats are verbal conduct.
Okay, if that's an indication that this is not offered for the truth, that it's a command or
Yes,
something along those lines, then I'll have the prosecutor respond to that.
it is.
And
You're-
a command or is like a question. It's not offered for the, it's not really an assertion, so to speak.
Judge, I disagree with what defense is trying to do. He's trying to get the previous question into evidence through another way, through a back door, so to speak. He previously asked her, I think it was the previous question, did you threaten the defendant? And she said no. So at this point, it's asked and answered as well.
If I may, Your Honor,
You may.
it's not asked and answered because here I went to a specific, you're not going to yell at me. And that is not hearsay. You're not going to yell at me as a command. I think it's even a threat, but it's at the very least a command. You're not going to yell at me.
I'm going to allow it. So the objection's overruled. And if you said that, or if you remember saying that, if you don't, you can say you don't remember.
I don't remember.
Okay.
But I don't remember saying that.
All
I
right,
wouldn't say that.
all right. And then let me return for a second. This is the point in time when you said, no, rephrase it, that today you're saying the gun was silver.
Yes.
when we were back here at the last
Judge,
hearing?
again, objection, asked and answered. He already went over this testimony.
Mr. White, are you just clarifying what you, I think you've asked these questions.
I'm moving.
Okay.
I'm moving. When your dog started barking at Catherine Davis, what did she do?
What did she do?
Yeah,
Like my dog or the person?
well, we've established that the dog was barking and she was barking at Catherine Davis. What did Catherine Davis do when the dog was barking at her?
She was yelling at me.
Okay, what did she physically do?
She was yelling at me.
Did she return to the car?
No, she was just standing there yelling at me.
And when the dog was barking, is that when she took the gun out that you say she had?
I don't remember. I know that my dog was barking and she was trying to get to her about pulling her closer to me, holding her between her legs. And then she said, I will kill you and my dog.
All right,
She said my dog is not gonna bite her when she was nowhere near her. And she said she made the threat.
so let's see if I understand the sequence right. You come out, you get this big argument about packages. And then you're walking towards her with your dog. Correct? You're yelling at her and walking towards her with the dog.
Yeah,
Okay, and the dog is barking.
not at that moment, no.
When did the dog start barking?
When she started yelling,
Okay, but the dog was barking before she produced the gun, right?
yeah, I don't know. I don't. You just making this all. I don't remember.
Okay, if you don't remember, you don't remember.
I don't remember if it was before she pulled the gun out or after she pulled the gun out. I don't remember. I just know my dog was barking.
Last question, did you not immediately retreat when you saw the gun?
What?
Did you not immediately retreat when you saw the gun?
No.
All right,
Because I had to, she said, oh, now your bass went down to your voice. Yeah, you got a gun pointed at you, what would you do?
well, that's not responsive to my question, sorry. Is your question that she pulled the gun and you did not retreat?
As in leave?
As in leave? Try to back up, try to get away.
Yes, I just said I did. I tried to back up.
All right, and at the same time, the dog was barking and pulling on the leash.
No,
All right, at what point in time was the dog barking and pulling on the leash?
how many times do I have to say when she was yelling at me?
Okay.
Redirect.
One minute, let me just confirm with my
Okay.
client, thank you.
You want to confer?
Thank
Are you
you.
all set, Mr. White?
I am set, thank you.
All right, cross-examination
Thank you, Judge.
or redirect, I should say redirect.
Ms. Powell, I'm gonna follow up on a couple of questions that Mr. White just asked you about. The first one, do you recall Mr. White asking you about the description of what this defendant was wearing and what her mother were wearing? Do you remember those questions?
Yes, ma'am.
Yes.
Okay, thank you.
Okay. And I think you testified that you don't recall exactly what they were wearing, other than the defendant had a black jacket on.
Yeah.
So my question for you, as the defendant sits here today, do you know this defendant is the one that pointed the gun at you?
I don't know. This one, I don't. Because it's been a year ago and I don't remember.
So looking,
I only seen her one time, so that was the day of the gun.
okay. And at this, when this happened, I think you testified that you didn't know them. Do you remember saying that?
Yeah, I don't know them.
Okay, now when you're saying, I don't know them, are you saying, I don't know them because you don't know their name? Or I've never seen them before, or what is it?
I don't know them like completely. I don't know their name. I don't know anything about them. I just knew that her mother stayed there and her mother was giving problems to the whole building, so.
Right. Okay, so you knew enough about defendant's mother to know that defendant's mother lived in the apartment complex. Is that a yes?
Yes, sir.
And so how many times would you say you had seen defendant's mother prior to this incident?
Probably 2 to 3 times, I believe. Probably more than that, but I don't really, when I just don't talk to people like that, so.
Okay, and there was discussion that you were arguing over packages or missing packages, is that right?
Yes,
And you had that argument over missing packages with this defendant's mother.
yes.
Had you seen this defendant prior to this incident?
No,
So this incident was the first time that you've ever seen this defendant?
yes.
And can you said that she was wearing a black jacket?
Yes.
Is that a yes? When you're having this verbal altercation, where is it inside of the apartment complex?
In the front, because we got a front area, is it across the street from the football, not football, but soccer field. They've got a back where we parked at, but it was in the front.
Okay. When you're having this verbal altercation, do you see defendant's mom come from the apartment where you think she lives?
No, they both were standing in front.
Okay. So they did not come from the defendant's mother's apartment?
No.
Okay. I know you said that you didn't know like of them this day. So how do you know that this defendant is the daughter of the person that you know in the apartment complex?
Yeah, I'm gonna object. This question, I know where she's trying to go with this. The question was asked and answered a few minutes ago. She said, do you know that this was the woman that was there? And she said no, unequivocally.
Okay, I'm gonna let her ask some questions. I may have some questions just to clear it up, but so I'm gonna allow the question to be asked. Ma'am, if you can answer that question.
What was the question again?
No worries. You have testified that this is the daughter of a person that you know lives in your apartment complex. Is that a yes?
Yes, sorry.
So how do you know that this defendant is that person's daughter?
Because like every time we come into court, why would she get an attitude with me? Like calling me ugly or saying all this stuff to me if you're not guilty of pulling the gun out?
Well, so that's not my question.
Your Honor, I'd ask that be stricken. That's completely non-responsive.
Well, it was non-responsive, but stricken means that it's just, we write strike after the testimony is recorded, so it's recorded.
So my question is before all of the court proceedings occurred. Okay, so I'm taking you back to this day, okay, back in December 2021. That day, did you know, and if so, how did you know that this defendant was that person's
I
daughter?
don't know. I haven't only seen her one time and it was that day. I don't remember.
Okay. So you weren't sure at that time when this incident occurred, you weren't sure the relationship between this defendant and the mom?
Your Honor, asked and
The
answered.
police told me
Oh,
that it was
overruled.
daughters. Well, mother and daughter.
Okay, so you got that information from somebody else.
The police, yeah.
This occurred, I think you testified during the day?
Mhm.
That a yes, ma'am?
Yes,
Is this like broad daylight? Is this dusk? What time of day?
broad daylight.
Okay. And I think you testified just on cross, this occurred under 10 minutes.
Under, yeah, under 10 minutes.
Okay.
10 minutes to worse.
Okay. And before the gun was pulled on you, did you have an opportunity to look at the person that pulled the gun on you?
No,
And were you talking, before the gun is pulled, were you talking to the person, so defendant's mom, the person that you know lives in the apartment complex?
yes, the mom.
Okay, so you were talking to her before the gun was pulled.
Mhm.
Is that a yes?
Yes,
Okay, were you looking at her?
the mom.
Yes.
Yes,
Okay, and you were having a verbal conversation with her.
yes,
Were you also talking to the defendant prior to the gun being pulled?
no.
And so when the gun was pulled, were you looking at the gun or were you looking at defendant's face?
The gun.
And approximately how long would you say the gun was out and pointed at you?
Probably less than a minute.
And while the gun was out, what was going through your mind?
I was scared.
And were you retreating when the gun got pulled on you?
Yeah, I was trying to get back to my unit.
And when you were retreating, were you like backpedaling away or did you turn your back and walk away?
I don't remember.
And your dog was on a leash?
Yes,
Was your dog on a leash for the entirety of this incident?
yes,
Do you recall the day of this incident, giving the police a physical description of the defendant, of the person that pulled the gun on you?
no, I don't recall. I don't remember. I just remember telling them what happened. I don't remember if I gave them a description or not.
And defense asked you about people that were involved on the scene. Do you remember that line of questioning? Whether there was 2 people or 3 people? Do you remember?
Yes,
Yes.
ma'am?
Okay, I know it's tough. When you testify that there were 2 people that were involved, what do you mean?
2 people involved, like,
Well, let me ask a better question. When you testify that there were 2 people, are you talking about there were 2 people that were out of the car, that were out on the
Yes.
sidewalk? Is that what you're talking about?
yes,
Okay. Do you know if there were other people that possibly observed this incident?
could have, I don't know.
Okay. Were you scanning the entire apartment complex looking
No.
for witnesses?
Mm-mm.
Nothing further, Judge.
All right, thank you. May this witness be excused from the people.
Yes, Your Honor.
May this witness be excused, Mr. White?
Yes.
All right. Without objection, the witness is excused. Thank you, ma'am, for your appearance. And the people may call their next witness.
Your Honor, at this time, people do not have any further witnesses.
Does the defense have any proofs today?
No proofs, thank you.
All right, motion for bind open.
Yes, Judge. Your Honor, we've now been together for 2 portions of this examination. And I will say right off the bat, that the issue here is going to be credibility and identification. This witness, I think, genuinely was doing her best to answer the questions and tell the truth about what happened here. This victim testified on direct when we were here back on February 9th. The victim testified that she was out walking her dog in this apartment complex. And she had, I think, experienced some packaging issues. She confronted this defendant's mother about that. The victim testified this defendant was with her mother when she was confronting her. A verbal altercation and argument transpired. The victim did have her dog. She said her dog was on a leash. And this victim testified that this defendant then pulled a gun out of her jacket and she pointed it at this victim. The victim testified it was pointed at her body. The victim testified that she was in fear. The victim testified that the gun was concealed in the defendant's jacket entirely. The victim did not see the weapon before it was pulled on her. It was concealed in the defendant's jacket. The defendant then pointed the gun at the victim while stating, threatening, I'm going to kill you and your dog. The victim testified that she saw the gun briefly. Again, today testified this occurred within 10 minutes or less. I think on redirect even said that this happened within a matter of just minutes. She was looking at the gun and that she started backtracking and she immediately called the police. I think, Your Honor, this victim's credibility is certainly for the court to assess, and whether or not the court believes that this victim testified to the elements of the crimes by a probable cause standard, whether a crime was committed and whether or not this defendant was the one that committed that crime. As to identification, I think today the victim admittedly did have some issues with identification. I know we were here previously and at the previous hearing when we were doing direct examination. This victim did not waver on identification. She pointed to the defendant at that time. She pointed to where she was sitting. She described what she was wearing and she said, that is the defendant. That is the person that pointed the gun at me. And here we are 2 weeks later. Today, the victim, I think, like I said, was a little wavering on the identification. This record does have identification of the defendant. I can't really explain some of the testimony that transpired other than I will say she did it, was to me very confident at the last portion of this exam that this was the person that pulled the gun on her. This was the person that threatened to kill her. And this was the person that was present for that incident. So I will leave it to the court to assess credibility. If the court finds that this victim is credible, then this court, I would argue, this court would find identification has been made and bind over would occur. I would say for the record, as I previously stated, the people are holding this exam, and if the elements were elicited, which I believe they have been, to add two counts to this information. It's currently charged count 1, felonious assault, and so I would request and move for the court to add a count 2, which would be CCW, carrying a concealed weapon, pursuant to MCL 750.227, and then a count 3 of felony firearm, which is MCL 750.227B-A, and the felony firearm would attach to the felonious assault. A handgun was used here in the commission of a felony, that felony being the felonious assault that occurred. I think the elements have been met for felonious assault, carrying a concealed weapon, and felony firearm by a probable cause standard again. Your Honor, if there's any possible fact issue as to, for example, the gun and whether or not it was silver or whether or not it was black, I would argue to the court that that creates a question of fact, and that would require this court to bind this case over to circuit court on the question of fact. With that, Your Honor, I would request that this court bind over on those 3 counts.
Thank you. Response?
Yeah, thank you. Your Honor. First of all, in relying on the identification, it's clear that today she could not identify Catra Davis. Now, as to the notion that she had any certitude the last time she testified here, the extent of the questioning of the identification occurs on page 10. And it begins, the lines aren't numbered, but on the bottom half. And when you were walking your dog, did you encounter Catra Davis, the defendant you ended today? She said, I believe so. I believe so. Today, she says, no. This is not a solid probable cause identification when later she comes back and says no. And the first time around, she can only come up with, I believe so. Secondly, as to where things attach in terms of a felonious assault. All right, I get that. I don't find the witness very credible. But one thing that hasn't been presented to the court is any evidence that this was even a functioning gun. So you can assault somebody with a non-functioning gun, but it's not felony firearm and it's not CCW if it's a non-functioning gun. So I would have to say that that if the identification is accepted by this court, and I don't believe it should be, that the maximum that you've got here is this felonious assault. Thank you.
Thank you. Just for the record, the victim was in the courtroom and asked to, out of sequestration, leave the courtroom by the court officer.
Excuse me. Sorry, was she escorted out? I know
Yes.
She was escorted out.
Thank you.
So, and I don't know if sequestration lasts after the testimony or not, but probably the safest avenue. So in regards to find the date of December 16, 2021, and the location of City of Lansing, Simkin Drive for this encounter to be both proven. The location, venue, and date, I believe to be proven by probable cause evidence. The offense elements, I believe, are proven with the intent to, I'm going to shoot you and your dog, were proven. So that would suffice for the felonious assault. The intent or belief from the defendant, according to the victim, that the gun was a working gun, is enough for probable cause. The CCW and the felon in possession, the CCW and the possession of firearm fall in. Really, it comes down to identification. I mean, as far as the court's concerned, I looked at the previous record that was made, and this is a probable cause standard. So it's a low standard. It's the second lowest standard. However, that's why we have prelims. Once we do direct and cross, we kind of filter out what maybe some of the vetting of the witness to make an understanding if we have a probable cause level standard, and that was done today. The identification of the individual in the previous preliminary examination on page 9, the court indicated. I indicated, okay, so this is Catra Davis. This is identification as the person sitting here. And the court said, okay, is there any objection? Counsel objected. And then we went through the exercise of yes, there was a mom and daughter there. And so let's back up. You're at the apartment. Is that day or night? I think you testified you were walking your dog. When you were walking your dog, did you encounter Catra Davis, the defendant you identified here as Catra Davis? I believe so. Okay, tell me more about that. Well, I was walking outside my dog. So it does start with the objection to the identification. And then for exam purposes indicating, I believe that is the person I saw. And then we get to today's date where Ms. Powell indicates that I don't know if that's the person. I can't identify the person, which leaves this court with a somewhat quandary as to whether this is the person. It makes logical sense that this would be the person with the mother who was setting up a self-defense claim in regards. But now I question whether the identification that was initially made and then the follow-up to that in which the witness says, I don't know, I can't identify that person, it becomes problematic to the court. I believe all other elements were made. I don't believe today the witness identified the defendant or it was able to. I believe that it was not a strong identification on February 9th, and therefore I'm not binding it over to circuit court based on identity. I believe the witness has some question at a probable cause standard as to whether this is the person identified as the individual who pulled a gun on them and who was also, in my opinion, whoever did that had a CCW and felon in possession. And that's a running 2-year. This person was not able to make identification today and was limited on their identification, briefly limited. I mean, we had the same issue as to, I don't know, but I think that's them. I find that identification to be a problem. So I'm going to deny bind over. I deny the motion for bind over, and this case is dismissed.
Thank you, Your Honor.
Thank you, Judge.
Thank you, Ms. Rolfe. Thank you, Mr. White. Anything else on file 22-00300? Ms. Rolfe?
Not on behalf of the people.
Okay, Mr. White?
Nothing for.
All right, you're all set, man. Thank you.
Thank you, Your Honor.
Time to log out as soon as he's come on her computer. and
Yes,
log
you
us around.
do.
Okay.
Yeah.
We're on the record in docket 23-00496. That's People of the State of Michigan versus Marcel Carter. Will the parties please introduce themselves for the record?
Mr. Stevens, on behalf of people.
Nick Gunner, Dale Coulter, yeah, Mr. Carter did appear today by Zoom. It's my understanding there may have been some confusion. I'm not quite sure about that at this point. And he's also indicated he's having some transportation problems. I do have a good phone number for him as of today. We have spoken on the phone. I can't speak for the people, but I don't think they're seeking a bench warrant today because he did appear. I've asked this be adjourned and placed on docket. We would like to hold the exam on this. And I can't speak for the people again. I don't know that anyone's inconvenienced except the court, which is a big inconvenience because I think they're going to perceive maybe victimless on this with 911 tape. So,
all right, Mr. Stevens.
I have no objection to the adjournment.
All right. So, sir, you are Marcel Carter?
Yes.
All right. It's my understanding. So just so there's no confusion, we're going to reset this today. We're going to reset this for preliminary examination. You're to appear in person on the date that we reset it for, okay?
Okay.
All right. So you should be in person because we're going to take proofs. And Mr. Coltrider, of course, is going to represent you, and you can cross-examine or contest any charges. But that hearing is to be in person on that date. So I don't see that he's waived his right to a 21-day, Mr. Coltrider. Are we seeking a good cause adjournment at this time?
I believe based on the fact he's not here, we voluntarily waive that.
All right. Okay. So may I inquire your client?
Okay.
All right. So Mr. Carter, you have a right to a preliminary examination within 21 days of your date of arraignment. Do you understand that?
Yes.
All right. And you, of course, didn't come in person. You came by Zoom. We're going to reset it today. Is it your intent today to waive your right to a prelim within 21 days? You won't be waiving your right to a prelim. Okay. We're going to have a prelim, but since you're seeking an adjournment, you didn't come in person. Do you waive your right to a prelim within that 21-day period?
Do I?
I don't know. You asked me. You tell me. I'm not sure. If not, then I will find this good cause to adjourn based on your non-appearance.
For the record, Your Honor, I would recommend my client that he do waive today.
Okay.
Because he's not here.
All right. So
I need his presence to hold.
yeah. So your attorney's recommending you waive your right to a prelim since we need your presence to hold a prelim, and you're not here. And I'm sure he's doing this in lieu of a bench warrant, or at least the expectancy of a bench warrant. I understand the miscommunication. Would you like to waive your right to a prelim within 21 days so we can actually have the prelim with you here?
Yes.
All right. I find the waiver. Any questions on the waiver of the 21-day rule, Mr. Stevens?
No, Your Honor, thank you.
Mr. Coltrider?
No, Your Honor.
All right. So the waiver of the 21-day rule is good. We're going to reset this for preliminary examination. And that date is?
March 30th.
Let's do that. March 30th at 9:30. All right. So, Mr. Carter, your exam date is set for March 30th at 9:30. That's live in person, okay? You have to be here for that, all right, sir?
Yes, sir.
That'll be on the 6th floor of the City Hall building. Anything else, Mr. Stevens, in regards to file 23-00496?
Nothing from the people. Thank you.
Anything, Mr. Coltrider? All right, thank you. That's all for the record. We'll see you on the 30th at 9:30. All right, sir?
All right, thank you.
All right, you're free to leave the Zoom courtroom. Thank you for your appearance today.
By my notes, we have one more, and I need to sort of touch
All
base
right.
with Mr. Hess.
Let's compare notes.
Okay.
Okay. Mr. Werwin is,
Those were
that's a leave-on?
correct.
Okay, perfect. And then Ms. Strunk?
And that's the one.
That's
I
the
need
one?
to Confer with.
All
Mr.
right,
Hess.
what about, I have also a Thornton file, which is Miss Sutter. That was a review.
Have that.
was set for. I don't know what we discussed with that.
All right, so don't worry about that one. And that's my one. We're all set, yeah?
for your time today. Ryan.
Thank you, Mr. Call Rider. Have a nice weekend.
I printed it to our computer.
Ms. Wayne, you're here for the 130 matter?
Yes, Your Honor.
All right, that's Mr. Murray. And this was set for live hearing, but we talked to an attorney, I think it was Mr. Woodrow, I'm not sure. But we told him not to bother driving in from, and then now we have your law firm, but Mr. Kozort's here on behalf of the defendant from Legal Services. I don't know if you want to meet with him beforehand, but we'll probably pick a new date and get something. We'll just put a time aside for it so we get something early if we have a hearing, or you can meet with him. It's up to you. I haven't called the case or anything, so. Mr. Kozart, do you have the opportunity to speak with Ms. Way in this matter?
Yeah, I spoke with Miss Way yesterday afternoon.
All right. So let's wait for Kelly to come in and we'll put it on the record. All right.
Is it possible to move forward today, Your Honor? Given the circumstances of the case, the property's been red tagged, so my client's a little concerned of the circumstances of the case.
Right. I understand. We'll put that on the record. If we did set it, we'd set it right if we did set it for live hearing, it would be set pretty quickly. We just find a place to put it. So I don't know if you wanted to start your proofs, I would take that on the record, but most likely I'm not big on cross-examination by Zoom, but we could start it today. Sure. That's not that's not an issue. And certainly if Legal Services involved, then they're contesting it somewhat, so.
Your Honor, I was wanting to make sure that you had received, we did file an answer with a jury demand.
All right, we'll put this, Kelly, we'll put this all on the record. We're just kind of yakking about the case. But Wendy'd be losing her mind right now if we,
Sorry, Wendy.
Yeah, sorry, kind of not sorry, I don't have an appearance yet. In our file, Mr. Colson.
It was sent to the Flores email yesterday. I believe I have a full.
Okay.
I have a copy of the answer, the appearance and everything. I don't have a copy in front of me, but
all right,
that should have been.
I just don't have a copy in the file. It's probably still making its way to the file.
If you would like, I have this copy right here.
Keep it, and then we'll
Okay.
And is there a jury demand in that file, in that copy?
Yes, Your Honor.
So are you requesting a jury trial at this time?
Yes.
All right, so we're probably looking at the earliest civil jury trial date we have.
We don't schedule.
Oh, that's
jury.
right, they do, don't they?
They do, but I don't know if you do civil pre-trials prior to get everything, because I can schedule that for you. but-
Yeah, let's go ahead and schedule it, but let's put it on the record
All
then,
right, hang
so.
on. Just one second. You know,
And then the earliest civil jury trial date. Oh, you don't do that.
we don't do that.
All right, you don't do that. I just asked the same question twice.
You're
All
all
right.
right.
It's already been a long day.
Yeah. We've already had a few prelims today.
Oh,
Yeah, all
Like
right.
nothing like the 25 count you had over the weekend.
Nothing like the 25 count I had over the weekend. I was tired of hearing myself. So we're on the record in docket 2203-924. That is LG Everett LLC versus James Murray. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Cassandra Wyant, P 83509 on behalf of the plaintiff.
All right, and go ahead, Mr. Colson.
Your Honor, Adam Kazor here on behalf of the defendant, P 78363.
And sir, you're also James Murray. You're also here.
Yes, I am, sir.
All right, and then Ms. Wayne, your property manager, Bessie Clark's here.
Yes, Your Honor.
All right. This is the time initially set for hearing in the matter. There's a hearing on a non-payment matter. And I have here in a previous proceeding that all parties appeared on February 22nd. We sent it to Legal Services South Central Michigan, who are now a part of the case, and we're just awaiting their appearance to catch up with the file. This was set for live hearing at 1:30 today, and then several things occurred. Yesterday, we found out that there was a storm coming, and so I looked at the last attorney of record at the request of my court officer, and we had Detroit, Michigan for Mr. Woodrow. So we made him make sure that he knew because of the weather, not to drive from Detroit or not. So that was part one of what we did. part two of what so now we've come here. Miss Wayant here, she's from the Trowbridge Law Firm. Is that in Detroit or is that is that here in East Lansing, ma'am?
That's in Detroit. I work with Mr. Woodrow.
All right. So Detroit Law Firm here by Zoom, which we've okayed the appearance by Zoom, and then Mr. Cozart, did I say that correct? Cozart came representing the defendant, is indicated he's filed an appearance. He has a copy of his appearance, and he says that he's filed an appearance for the record. And the court's just waiting for the appearance to catch up because I don't have the appearance. But regardless, and it's part of that appearance. My understanding is a request for jury trial. Is that correct?
Yes, Your Honor.
All
That's
right.
part of our answer.
So I guess now I'm put in a position where legal services involved. They've requested a jury trial. We don't schedule those, so that we will be scheduling that. So it's the civil department will be scheduling that, Ms. Wayant, and I will set it for a pretrial on the civil case, just to make sure that the case is on moving. I'm uncertain when they're setting the civil jury trial for, because but I can set this for a pretrial on the matter, okay, so we'll set, so all parties appeared. Definitely, yeah. So all parties appeared. Legal Services of South Central Michigan appeared. And will present or has filed an appearance. We will set it for a civil pretrial on for jury trial, and that is
The civil one is on the 20th at 8:30.
so March 20th at 8:30. That'll be the next thing. So we'll consider any jury trial options or anything, instructions. Just come prepared to talk about all that, all those. And then by that time, we will have a jury trial date, I would assume.
No, because if they have to do the discovery.
All right.
That's when they talk
Yeah.
about all that, and then they schedule.
So that's absolutely right. So I would venture a guess that that the civil jury trial would be scheduled sometime after the March 20th date, Ms. Wayant. And now that we've set it for jury trial, and now that we've set it for jury trial, it's to be set for jury trial. In the meantime, you can speak to Mr. Cozart about but there is an appearance for jury trial. They have a right to a jury trial. So I'm setting it for civil pretrial on March 20th, and then the jury trial will be set sometime after that date, following the rules. Ms. Wayne, do you have any questions concerning that? I know you were looking for an earlier hearing, but once it's been set once the jury trial appearance has been requested, there's a process that we run right into.
I do understand. I just want to make note of my concern for the record, Your Honor. The building's been red tagged. The city says that no one can be residing there. It's our understanding that he is residing and staying the night over there. Our client has offered other options, and opposing counsel hasn't even acknowledged in his answer that the property has been red tagged. The city says that no one can be there.
Right.
We can't force him out. You know, this is the process. So our client can't do anything, and you know, they're trying to comply with the city.
Mr. Cozart, to your understanding, your client's still in the residence. It has been red tagged. I don't, you don't want to make admissions on your clients, but the city's going to take action if need be.
I understand that, Your Honor. Mr. Murray has been made aware of the city's intention.
All right, so Mr. Murray, you understand, at least you understand all the aspects that are going on right now.
I'm aware, Your Honor.
All right.
Some things are not being made aware, but.
All right, all I'm saying is that if the city wants to pursue the claim that you're living under a red tag in the house, I mean, that's going to happen regardless of this hearing. You understand that?
I understand. What I do not understand, Your Honor, is the reason for the red tag. There is no reason for it.
That's between you and the city at this point. That's between you and the city. this hearing is going to go on for March 20th at pretrial and then jury trial in regards to that. But just so we have an understanding of where everything is right now, you may have some allegations against the city, but that's not a part of this atmosphere, at least at this time. So March 20th is the date for civil pretrial at 8:30. Anything else for the record on docket 22-03-924? Ms. Wayant?
Just for clarification, is that via Zoom or in person, Your Honor?
The civil pretrial can definitely be by Zoom.
Thank you.
Yeah. And then but for the jury trial, obviously, everybody will be in person when we get that date. Anything else from Legal Services of South Central Michigan on file 22-03-924?
Not at this time, Your Honor.
All right, we'll see everybody on the 20th, all right?
Thank you, Your Honor.
All right,
Thank you.
thank you.